Okay, welcome back to the Royal Courts of Justice in London. This has been the first half of the extradition hearing for Julian Assange. I'm here with Matt Kennard, the editor of Declassified. Matt, what did you see this morning?
Well, firstly, it's worth noting that, as usual with the British justice system, it's very hard to access the case. So we were sat in an annex room, and you can barely hear the arguments of the Assange lawyers. The stuff I did hear, though, basically they were outlining grounds for appeal, which for me were just ironclad. There's no way you can. These substantive issues shouldn't be heard in the British court. Fitzgerald started with, and his arguments mainly revolved around the fact that this is clearly a political case, because by all definitions, even if you charge Assange with espionage is a political offence, and political offences are outlawed by Article 4 of the Anglo-American Extradition Treaty. So that was a long argument about that, mainly saying that the judge didn't consider various parts of that argument. In Barait's original ruling, she didn't delve into the political nature of the case. She said it wasn't relevant. So a court needs to hear those full arguments heard. And in fact, we published a story at Declassified by David Davis, the Tory MP, former minister, Brexit minister, who said, and he was one of the people who designed the US-UK extradition treaty, and he said that Baraitza had misinterpreted that treaty. And then Summers, the second lawyer, his arguments revolved around the fact that this is a retaliation from the United States. It's obviously a political case, but it's also a retaliation and a bad faith use of the extradition treaty, because, and he referenced particularly the Yahoo News article, which came out in after the original Baraitza ruling. So that information wasn't available, so that needs to be heard in a open court as well. And the Yahoo News article was 34 US officials saying that the Trump administration, senior levels of the CIA, but also the Trump administration, the political administration, the executive, had sketched plans to kill or kidnap Assange in London. So, in my opinion, any extradition case should be thrown out immediately when you have evidence that the country that wants to extradite this person has had plans for extrajudicial rendition and extrajudicial murder. That should be. I mean, it's amazing it hasn't been thrown out already, but it would be even more amazing if they won't even let those arguments be heard in court, because there's no precedent for this. There's no precedent for extraditing a journalist to a third country. Britain's never done it for the crime of exposing war crimes and embarrassing the political leadership. So I thought that, to be honest, the lawyers did a very good job, particularly Summers, and it was super convincing, but I'll finish with this. We've done a lot of work at Declassified, and I think anyone who's looked at this case knows that it's a bit of a mistake to put any faith in the British justice system, because although you sit in that court and you listen to these arguments and you think you can't argue against these, or at least the 100% need to be heard in a democratic system which applies the rule of law, but we've seen time and time again that that's not how the British justice system works in this case. I think that Assange is playing at a level which is above all the niceties we understand about the rule of law and due process and stuff. So I hope that this judge is independent and can evaluate the fact that we need to hear these arguments, but I don't hold up much hope. I just reiterate that this isn't a decision by these judges to free Assange. This is about, can they even hear an appeal on the original ruling? This is basic justice. Basic justice, you should be able to appeal against the ruling that's going to send you to a what they call a concrete coffin in the desert for the rest of your life for the crime of doing journalism. So the stakes are extremely, extremely high, not only for journalism, but also for the reputation of the British justice system now and forever. Because if this happens, there's no way back.
You've covered the relationship between Assange and the intelligence community and the defense community. And also you've covered the relationship that these judges that have ruled in several occasions have a relatively close relationship with these intelligence. Can you?
Well, I think the main the judge today, she has acted previously for MI6 as a client. The previous judge, Jonathan Swift, had acted for the British intelligence agencies and said actually his favourite clients were British intelligence because they put their evidence together very neatly. So there's massive conflicts of interest. I mean, the major conflict of interest that we discovered was Chief Justice Ian Burnett, who overruled Baraitser's original ruling. So Baraitser in late 2021, on narrow health grounds, blocked the extradition, and then Chief Justice Ian Burnett overruled her decision and accepted US assurances about Assange's treatment when he was in the US. But Chief Justice Burnett, he's a 40-year good friend of the Tory minister who orchestrated Assange's arrest in 2019. His name's Sir Alan Duncan. And he, from 2016 to 2019, he was Minister for Latin America as part of the Cameron government and later Theresa May. I mean, that is a clear conflict of interest. And actually, from what I've been told by people in the legal system, even if there's a hint of a conflict of interest, a judge recuses himself. But the evidence of that only came out because Alan Duncan published a memoir in which he admitted that Burnett was his friend. He also gave the first evidence we have of the UK state involvement in the persecution of Assange, because we didn't even know that Operation Pelican existed before that book was published. Operation Pelican was a secret police operation to spring Assange from the embassy. And I'll just finish with this, the other thing that we discovered was that 15 UK government staff had been assigned to Operation Pelican across 3 different ministries. So huge state interference in a case which they should have nothing to do with. This was a legitimate application for asylum to avoid persecution, which we're now seeing. Asylum is a right enshrined in the Universal Declaration of Human Rights. No government should be putting 15 of its own staff on an operation to get someone out of that legitimate asylum. So the case is riven with conflicts of interest, with irregularities. The fact is, even in Belmarsh Maximum Security Prison, never been charged with a violent offence. He's only been found guilty of a bail violation. Why is he in a maximum security prison with paedophiles and terrorists and rapists? It's ridiculous. So the state is heavily involved in this case. I think it's exposed the British justice system as not independent, and that is a fundamental tenet of any democratic society, and we should all be worried.
Thank you very much, Matt. Revealing the ties between the intelligence community and the Assange case. Assange has been, the intelligence community has been the biggest lobby towards Julian imprisonment and silencing. We'll be back shortly. Thank you.